My hair's a mess, but I'm here. So I'm Alan Childress. I'm the Tulane law professor who also co-teaches courses in notary prep. And this is second in a series of book reviews with a purpose, which is to learn something from rather than to just rag on the book, though I do rag on the books. So Amazon has a habit of allowing anybody to publish anything and slap the word Louisiana on the cover. And they always get tons of good reviews that are clearly manufactured by the company. I don't want to say person who puts them out, because a lot of times these names are so generic, like Roger Sullivan, that they don't seem to be a real person. Certainly are not a Louisiana notary. So they're just crap, and they get away with it. Most of the reviews on the website look like they aren't verified purchases. So apparently, there's a whole industry of people who will quickly give good reviews. The book that I'm reviewing today says 2526 on the cover, but it was written in or published in April of 2024. So it can't take into account the changes that are coming, according to the Secretary of State, as to the testing format that'll probably come after the May or June exam. So it's already out of date despite having 2026 on the cover, or it will be out of date soon enough. But that isn't the main problem with it. It's a little bit of false advertising. Another false advertising, it says 740 questions on it. And then you get to the end of the book and there are 370 questions on it only. It says it's comprehensive and all in one and complete. But from everything I can look at, it really only covers at best chapters 1 through 7 in the study guide, which you'll recognize is 30 chapters in. So it covers to here, this little part of the book. And of course, the exam is mostly on the rest of it. So even if you got everything right according to what this book says is right, and those were the right answers, you would only have learned enough to get a few questions right. Now, chapters 1 through 7 in the study guide are decently tested. There's a certain number of questions on the Office of the Notary Public. But of course, the hardest material, the ones that you really need a book that explains it to you, have to do with chapters 8 through 30. The book I would recommend, to see if I have a copy of my own book handy. I don't, so I'll recommend Michelle's book. If you want kind of a summary of, or an outline of the study guide that explains it in simplified terms, this is on Amazon, Barnes & Noble, and the ebooks are very affordable on Apple or Kindle. So easy to find that book and to do it. My book is called The Side Piece, but there's also another book that Amazon just published called Side Piece, stealing my title and my subtitle. But anyway, that I'll review that one in due time. So this one actually is a modern version or an updated version of one that was a bigger size and probably 2024, didn't have a date on it, that also Roger Sullivan purported to have written. But most of the questions, and it's just republished under a different cover and a different format, but it's pretty much the same book. I don't have that one anymore. I got so frustrated with it about halfway through it that I just threw it in the garbage can. And I didn't realize later I might have saved it to talk about it with my classes and other things. But let me tell you some of the things that are wrong in here that will teach you something about the study guide and about the actual exam. So starting with that it's not comprehensive and that it only covers a small and rather easy chunk of the study guide. But here are some other things. Just there's a part of it that is kind of textual, gives you information, and then most of the book is sample questions, or about half the book is sample questions. But some of the things they say wrong early on that I've marked here is that they say that the exam is a partially short answer and essay, but the exam is all multiple choice and has been for about 7 years, 8 years. So that's heavily out of date at best. And I don't think it ever was an essay exam. They had you writing some acts at some point. In their chapter on the civil law in Louisiana, they say that the Louisiana Civil Code draws heavily from the French Napoleonic Code. And I think they read the book wrong, and they may be right in terms of what you learned in high school civics. But you'll see on page 17 of the state study guide that the origins of the Louisiana Civil Code have common origins with the Napoleonic Code, but it isn't the Napoleonic Code. And that would be a tricky one that they might ask on the exam, and you'd get wrong if you followed this stereotype that's in this book. Another thing on page 21, they say, unique among notaries in the United States, Louisiana notaries have the authority to officiate marriage ceremonies. I wish we did. We don't. That would be a wrong answer on the exam. There's only one parish, and that's West Feliciana, that automatically allows its notaries to be officiants for weddings as well. So that's just, got these wrong. Okay, which way do they go? That is just wrong. And I don't know even why they mention that, because that isn't mentioned anywhere in the study guide. So they are deriving this from AI or some sources, and maybe by finding one parish that allowed it, they just extrapolated that all the other ones do too. That's a wrong answer. The next page, their page 22, they talk about the notaries in Louisiana play a role in careful drafting and review of legal documents. Well, we do draft legal documents, and that makes us very different from notaries in any other state. But review of legal documents sounds like that we give legal opinions about them, and we do not do that. That would be the unauthorized practice of law. And they do test fairly regularly on the limits of what civil law notaries may do in Louisiana. So you wouldn't want to say that you review legal documents. I understand that if somebody gives you an affidavit, you review it in the sense of you look it over to make sure that it has a jurat on it and it has evidence of oath and the other attributes that are required for an affidavit here. But it's not like you're giving a legal opinion, or people bring in a contract and say, review this to me and tell me if it's a good contract for my position. We're not allowed to do that. My dogs are going crazy. That means either Amazon's here or something's going on. Sorry about that. Regulatory oversight. This is on page 26. It says the Louisiana Supreme Court's regulatory activities significantly influence the notarial profession. Well, the book actually is very clear early on. I forget which chapter, if it's 5 or 6, that the Louisiana Supreme Court does, in fact, take lawyers and do all the disciplinary review ultimately for lawyer discipline. But they distinguish that isn't true for notaries or non-lawyer notaries. And therefore, this would be a wrong answer on the exam. And you need to know that the Louisiana Supreme Court's role regarding the legal profession is largely with the lawyer side of that, not the notary side of it. Rather, we are regulated more directly, the study guide says, by the district court. That's the trial court, the lower level court. Ultimately, maybe something could wind up in the Louisiana Supreme Court, but there's nothing in the book for the exam that suggests that. Instead, if you'll see in Appendix A, where they give the Title 35, the notary statute, it says that the district court is the place where discipline is brought for cause, for us doing something that's wrong. Other discipline can be imposed by the Secretary of State using automatic revocation or suspension based on things like we move out of the state, or we lose the ability to vote if we're a citizen, we have a felony conviction. So Chapter 7 of the study guide makes a lot of distinctions between what the Secretary of State can do, automatic suspension or revocation, versus what a court could do to you with a complaint brought by the Attorney General or the local district attorney. So that's a distinction they could easily test on that this book has wrong. Let me flip to a few other things. They talk about the advisory role of the notary, that given their extensive legal powers, Louisiana notaries often serve in an advisory capacity, guiding individuals through complex legal procedures. We don't do that. We're not going to give legal advice. And I'm not denigrating what we do. It is, in fact, way more than any non-lawyer notary would do in any other state. So I'm really proud of the tradition of the civil law notary and the massive amount of effect it has on the legal profession. But we are not legal advisors. We're not in an advisory capacity, despite what this book says. And it repeats it a few pages later. We often serve in an advisory capacity. It's just not true. A lot of the book, by the way, just repeats itself. So it fills out a lot of pages by just saying the same things over and over again. So at best, then it's a waste of money. Here's where it says the format of the exam, and it says it in a few other places: multiple choice, short answer, and essay. It isn't. It's multiple choice. When you get to the actual sample questions they have, they don't even really use the format of the current state exam. For example, ours is multiple choice with 4 or 5 answer choices, whereas all of the answer choices in all the problems they have in their 370, which they think is 740, their 370 questions have 3 choices. So they're easier than the actual exam and don't really prepare you for it. But more to the point, the practice tests here are always in the form of just asking a question. And most of the questions you'll get on the state notary exam don't just ask you a question, they give you a fact pattern that they call a scenario that describes people doing a transaction or people seeking a goal, and then ask you which document does that, or otherwise test you on the scenario or fact pattern, the kind of historical snippet. Much harder to do than just answer a straightforward question. What is the primary role of a notary in Louisiana? Their question number 1. And then they have 3 options. So super easy question compared to what you will get on the actual notary exam. I noticed also that almost all of these questions, like the rest of the book, test things from chapters 1 through 7 in the study guide, with an occasional question that I would say fits more with chapter 19 on juridical acts, but nothing on property ownership, wills, the role of the notary with leases and suretyships, mortgages, heavily tested, conveyances of land are heavily tested, are not anywhere in this book. Here's some of the first 20 questions. I didn't keep going and going, though I found a few other bad examples. But here's some things you can learn from their mistake. Number 2, in Louisiana, a notary's commission is A, valid throughout the U.S.? No. B, valid only in the parish of issuance? No. C, valid statewide? No. This teaches you that you need to be very careful in how they word questions. They think the answer is valid statewide because for any notary that becomes commissioned now, that's true. But they didn't say a notary who was commissioned after 2005 has a commission that is blank. By the way, they're saying commission when in fact they mean jurisdiction, and the distinction between commission and jurisdiction that's on about page 59 of the study guide is heavily tested. There's a big difference between having a parish commission but a statewide jurisdiction. But the thing I think you really need to learn from this is not just they have the answer wrong, but the way they worded it is you can make a big mistake on the actual exam if you read something into the question. So if they said a notary's commission is valid statewide, is this true or false? And they would ask just a true false question. But if they asked it that way, you would have to say, well, it depends, or the answer is not necessarily, because they didn't specify whether it was somebody who got their commission before 2005 or after 2005. So admittedly today, like a notary's commission, parentheses, received after 2005, close parentheses, is still a parish commission, but a statewide jurisdiction. So the way they worded this means they don't even understand the very basics of how we divide up authority and regulation of the notary. So I think they're just skimming this book or having AI skim this book and then come up with questions that are kind of okay, but just wrong enough that you would get it wrong on the exam. Number 3 says, which of the following is a requirement for becoming a notary in Louisiana? And one of them is it must be a registered voter in California. It makes me think that this book, a similar book, is sold in California and they forgot to take out the word California and put in Louisiana, because there's no way one of the answers is you have to be a registered voter in California. So it's already way too easy a question by eliminating that. Um, and then the other two choices, must have a law degree. We know that's not true. Then obviously the choices must be at least 18 years of age and a resident of Louisiana. Well, okay, but that's a pretty simple question if you eliminate two really bad answers. Number four, they say, what types of acts can a Louisiana notary public perform? And their answer is both judicial and non-judicial acts. They've mixed up the word juridical with judicial. We don't perform judicial acts. Judges issue judicial acts. Even in terms of drafting an order for a judge to sign, Chapter 19 makes clear that non-lawyer notaries don't do that either. So even if you read judicial acts as judicial drafts of an act or acts for a judge to sign, this wouldn't be a correct answer. So that's just stupid. But mostly I use it to tell you to notice the subtle distinction between the word juridical and judicial. Juridical means pertaining to law or having legal effect, whereas judicial is judge. So yeah, we do draft juridical acts, both juridical and non-juridical acts, though I don't understand what a non-juridical act would be. So an act that has no meaning in the law, nobody's going to go to a notary to ask you to draft something that has nothing to do with law. So it's just a poorly worded question. And but know the difference between juridical, which notaries do and lawyers do as well. A will is a juridical act, a contract is a juridical act, a lease is a juridical act, and a donation is a juridical act. Yeah, we do those, but that's not judicial. Number 8 is what is required for a document to be considered notarially executed in Louisiana? And they say it must be signed by 2 witnesses. They've mixed up a notarized act with an authentic act. Heavily tested that you know what an authentic act is, and it does require 2 witnesses. An authentic act is the highest form of juridical act that has all these formalities, including extra process and especially the signing by 2 witnesses. So, but that's not a notarial act or a notarized act. Is this to consider notarially executed in Louisiana? No, you're going to do it as a commissioned notary. You're going to do lots of forms that are not authentic acts that you would say they're notarially executed. Somebody brings up an affidavit to you or a form to you, something from the school that has to show where your residence is. You're going to do that as a notary without it being witnessed. So that's just a wrong answer. In Louisiana, number 9, a notary's official seal must include the words notary public and the notary's name as it appears on the commission. They've confused the word seal as it's used in other states with the word seal as we use it in Louisiana. Chapter 7 makes clear, somewhere around page 76 or so, that the notary's signature is her seal. So it isn't a stamp, and it doesn't have the word notary public in it, unless that happens to be your name, coincidentally. Great name to have. Very confusing, though, if you're going to be named that and be a notary. So that's just a wrong answer. And again, on one that should be an easy, free point on the exam, when they ask you, what is the notary seal? And the answer should be his or her signature. And that isn't even an option here. Number 10, which of the following statements about notarizing wills in Louisiana is true? And they want the answer, a notary cannot notarize a will in which they are a beneficiary. That is the best answer of the 3 that they give, because the other 2 are just completely ridiculous. It's still not right. And I did want to remind you or teach you that there are rules about that. That is to say, it is not proper for us to notarize a will that we are also a recipient in, or beneficiary, as they call it here. Really, the word would be legatee. That's true. We're not supposed to do that. But the punishment for that isn't that the will is invalid. And they frequently test on, well, does that make the will invalid? That the notary is also receiving a watch in the will. No, it doesn't get rid of the whole will. It only gets rid of the watch for the notary. The notary can't receive the legacy as a legatee under the will if they're also the notary in the will. So to say they cannot do it, maybe it would be improper to do it, would be a better way of wording that, but that's very sloppy. And I will tell you, the actual exam is not sloppy. They're very precise about that. They have something wrong about how a movable property, which would be like watches or cars, requires notarization only if the movable property sales are over $500. Well, actually, most sales of movables in the state don't require notarization. You do need notarization to transfer the title, but the bill of sale not necessarily needed, and certainly something not having to do with a car or a motor vehicle. And they only say a movable property. They don't say a motor vehicle, a titled motor vehicle. People can do an active sale or a bill of sale to sell a watch or to sell a iPad easily, or equipment that's not titled, easily could do that without a notary. So that's just wrong. In Louisiana, a notary can refuse to notarize a document if the signer is not wearing formal attire. No, we don't check tuxedos before we do that. But the correct answer they want is the document is in a language the notary does not understand. Well, in fact, we must refuse to notarize a document, at least an authentic act where we are a part of the presentation of that. That may not be necessarily true of an affidavit or something where we don't have to know the contents that are sworn to. We'd have to know the rest of the document. I guess if the whole thing is in Laotian, you can't do it unless you speak or write Laotian. Um, but so this is kind of worded poorly in the sense that you can refuse it. You can refuse to notarize any act. Um, they have a lot of questions about requiring a journal. Uh, there's no mention in this that I could find about keeping a journal, and it is not a legal requirement. It's a custom. A lot of people do it, but it's not required. What type of record is the Louisiana notary required to maintain? And their answer is a chronological journal of notarial acts. And if it was just one isolated question, I'd say, okay, well, they missed that. But I would say maybe 15 other questions are about you must keep a journal. So you would get that wrong 15 times in here, or you'd get it right, and they got it wrong 15 times. So that's almost it. I did have a few others along the way that I just really stood out to me. I hope I found them and marked them. And so don't see any chat questions where you yourself have any questions to follow up on what I've been saying here. But I thought you might. Oh, here's one. Can a Louisiana notary public draft juridical acts for clients? The answer is yes, if the notary is also a licensed attorney. Well, their answer is yes, if the notary is also a licensed attorney. That is not true. We draft a lot of juridical acts. In fact, juridical acts for clients that are not going to court, they're not petitions for the court or responses, answers to a lawsuit. Yeah, we don't do things that are designed for court. But the rest of the juridical acts, the things that are truly out of court juridical acts, like a will or an act of donation or an affidavit, we non-lawyer notaries do draft them, and that's unique among the 49 states. 49 other states, the District of Columbia, do not allow non-lawyer notaries to draft juridical acts. So question 317 is correct for every other state except Louisiana that they purport this book to be about. And I think that's the last one I wanted to say. Just I can't believe they got that. That's not even consistent earlier with them saying that you draft judicial acts. If what they meant was juridical acts, it's like they're not even making sure that the answer to this question is consistent with the answer to this question. It is fraud. I can't believe Amazon gets away with selling this. I can't believe that people might buy this book because they see all the good reviews of it and the cover is impressive and It promises a lot. It's comprehensive. This is all you need to pass the notary exam. Well, no, you need at least this. And I would recommend other books like My Side Piece and Michelle's Outline to help you really understand it. Okay, thanks, Sam, for chipping in. And I just wanted to give you another book review with a purpose to tell you what's not just what's wrong with the book, but what the right answer really would be for the exam. And I hope to do that again over the next few weeks. Probably not next week, but maybe 2 weeks from now. Invite more people to attend, and otherwise keep this on YouTube for people to view. I don't criticize real books in Louisiana by real Louisiana notaries, but I will criticize something that's clearly not written by a Louisiana notary, and I think it's just AI generated. It's like they took everything you could find on the internet about notaries and put it together and then put Louisiana on the cover. And they did at least tap into the first 6 or 7 chapters of this book enough to use some of the terms like Napoleonic Code, but then use them wrong. So there you go. I will end the stream and see you in class if you're one of my students. Bye, guys.